Hello friends, today in the present lecture of CPC, I am going to discuss with you very important topic of CPC, and that topic is place of suing. Why I am saying that this topic is very important? Because when the plaintiff intend to file the civil suit against any defendant, then generally the first questions which arises in the mind of plaintiff that where I should file my civil suit against the defendant. These questions of the plaintiff will be answered by section number 15 to 20 of CPC, which deals with the provisions relating to the place of suing, out of which section 15 of the code requires the plaintiff that he should file his civil suit in the court which is of the lowest grade and which court is competent to try the civil suit. Section number 16 to 18 of the code deals with those suits which are related with the immovable property. After section number 18, section number 19 of the code applies to the suits when any compensation is demanded by the plaintiff in respect of wrong which are caused to the person or to the movable property. After section number 19, there is a section number 20 which is a residuary section, and it covers all the cases which are not dealt with by section number 15 to 19 of the code. That means to say, if any particular civil suit is not covered by the provisions of section number 15 to 19 of the code, then that case can be filed with the assistance of section number 20 of CPC, which is the residuary section, and it covers all the cases which are not dealt with by section number 15 to 19 of the code. Section number 21 is also very important because it recognizes the well-established principle that the defect as to the territorial or pecuniary jurisdiction, can be waived by the appellate or revisional court in certain cases. And what will be the certain cases in which this defect can be waived? If the objection as to the territorial or pecuniary jurisdiction was not taken by the defendant in the lowest court, then that objection can be waived by the appellate or revisional court. Section number 21 of the code says that you cannot set aside a decree which is passed by a court on the ground of want of territorial jurisdiction by filing a civil suit. That is, section number 21 of the code bars a substantive suit for setting aside a decree which is passed by a court on the ground of want of territorial jurisdiction. So we will discuss all these sections one by one, but in the present video I am going to discuss with you section number 15 of the code. Section number 15 of the code start from the heading court in which the suit is to be instituted. According to section 15 of the code, every suit, that means every civil suit, shall be instituted in the court of the lowest grade competent to try it. That means to say, when I am going to file any civil suit, that shall be instituted first of all in the court, and that court must be of the lowest grade, and that court of lowest grade must be competent to try that civil suit. That means to say that civil court must be competent to take the evidence to decide the case. If it is so, then it can be filed in that court. So I want to repeat section number 15 of the code. According to section number 15 of the code, every suit shall be instituted in the court of the lowest grade competent to try it. So let us study section number 15 in detail. Under section number 15 of the code, grade means pecuniary jurisdiction of the court. So as per section number 15 of the code, we can say that every civil suit shall be filed in the court of the lowest grade which is competent to try that civil suit. But it is very important to note here that the rule which is laid down under section number 15 of the code is only a rule of procedure. This rule is only a rule of procedure. This rule is not a rule of jurisdiction, and therefore exercise of jurisdiction by a court which is of the higher grade then is competent to try the suit is only a irregularity, it is mere irregularity, and if any decree is passed by that court of higher grade then is competent to try the suit, it is not a nullity. But on the vice versa, it is very important to note here that exercise of jurisdiction by a court of lower grade then is competent to try it is a nullity because it is without the jurisdiction. That means to say, if any court of higher grade then is competent to try the suit passes a decree, that is purely valid. But if any decree is passed by a court of lower grade then is competent to try it, that decree is null and void as being without jurisdiction. Let us try to understand this principle with the help of an example. City Civil Court and Small Causes Courts in Bombay, Madras and Calcutta, which are three presidency towns, have original jurisdiction in respect of civil suits. Okay. Now let us suppose that the pecuniary jurisdiction of the Small Causes Court is up to rupees 50,000. That means the pecuniary jurisdiction of the Small Causes Court is up to rupees 50,000. The Court of Small Causes Courts cannot entertain any suit more than rupees 50,000. Therefore, if any suit to recover rupees 40,000 is to be filed for damages for the breach of contract, it can be filed in any of the courts. It can be filed in City Civil Court, it can be filed in the Small Causes Courts. But according to section number 15 of the code, the suit must be filed in the court of the lowest grade which is competent to try it. That means it should be filed in the Small Causes Court. But if the suit is filed in the City Civil Court instead of Small Causes Courts, what will happen? And the decree is passed by the City Civil Court, then the decree passed by the City Civil Court is not a nullity and this decree is fully executable as per the law. But if the suit is filed for rupees 60,000, which is beyond the pecuniary jurisdiction of the Small Causes Courts, then what will happen? But if the suit is filed for rupees 60,000, which is beyond the pecuniary limit of the Small Causes Courts in the Small Causes Court instead of City Civil Court, then the decree which will be passed by the Small Causes Courts will be said to be nullity as it is without the jurisdiction. So what is the meaning of competency of the court? According to section number 15, the court should not only be the lowest court, but it must be the competent court. So it is very important to note here that court before which the civil suit is filed must be the competent court to try the suit at the time of filing the suit. It is very important what will be the relevant time in respect of competency of the court. It will be the time of filing the suit. That is, I want to repeat, it is very important to note here that the court before which the civil suit is filed must be the competent court to try the suit at the time of filing the suit. Subsequent change in the value in pecuniary jurisdiction of the court does not affect the jurisdiction of the court. If the court had pecuniary jurisdiction at the time when the suit was filed before the court, that is, what is the main time which is to be seen to check whether the court had the competence or not, it will be the time when the suit was filed in that court. Prima facie, what is more important to note in relation to the pecuniary jurisdiction of the court, it is the valuation which is made by the plaintiff in the plaint. It is the valuation of the suit which is made by the plaintiff in the plaint that it determines the jurisdiction of the court and not the amount for which ultimately the decree may be passed by the court. Let us take an example. If the pecuniary jurisdiction of the court is rupees 10 lakh, okay, if the pecuniary jurisdiction of the court is rupees 10 lakh and plaintiff files a suit for accounts, okay, and finally after taking the accounts of both the parties, the court finds that rupees 15 lakh is due towards the plaintiff, okay. Now here the pecuniary jurisdiction of the court is rupees 10 lakh, but the court finds that plaintiff is entitled for a sum of rupees 15 lakh, then the court is not deprived of its jurisdiction to pass a decree for that amount of rupees 15. So now we can say that every suit should be instituted in the court of lowest grade which is competent to try the suit. It is necessary that plaintiff approaches the most inferior court having the pecuniary jurisdiction. If the plaintiff chooses the wrong forum, What will happen if the plaintiff chooses the wrong forum and moves superior court directly? Then such superior court may return the plaint to the plaintiff under the provisions of order number 7, rule number 10 of the court, which deals with the return of plaint, to be presented to the court in which the suit should have been instituted. I want to repeat, if the plaintiff chooses the wrong forum and moves the superior court directly instead of court of lowest grade, then such court of superior jurisdiction may return the plaint to the plaintiff under the provisions of order number 7, rule number 10 of the code, to be presented to the court in which the civil suit should have been instituted. Okay, I want to repeat that the jurisdiction of the court is determined on the basis of plaintiff's valuation in the plaint. But it doesn't mean that plaintiff deliberately undervalue or overvalue the claim for selecting or rejecting a particular forum. I want to repeat, but the plaintiff cannot deliberately undervalue or overvalue the claim for selecting or rejecting a particular forum. Let us take an example. If the actual valuation of the suit is rupees 90,000, and as such it is triable by the Court of Civil Judge Union Division, which has pecuniary jurisdiction up to rupees 1 lakh, then the plaintiff cannot intentionally increases the valuation, say to rupees 1 lakh 10,000, so as to drag out the suit from the jurisdiction of the Court of Civil Judge Union Division, thereby enabling its institution before the Court of Civil Judge Senior Division. He cannot do so. Similarly, where the actual valuation of the suit is rupees 1,10,000 and as such it is triable by the Court of Civil Judge Senior Division only, then the plaintiff cannot reduce the valuation of the suit to rupees 90,000 in order to avoid the jurisdiction of the Court of Civil Judge Senior Division, thereby granting jurisdiction to the Court of Civil Judge Union Division. What will happen if the court has any doubt in respect of the valuation which is made by the plaintiff? What will happen? Where the court doubts that the valuation is made by the plaintiff for avoiding the jurisdiction of the proper court, then the court may require the plaintiff to prove that the valuation is proper valuation. If the suit is not correctly valued, then the court may return the plaint to the plaintiff to be filed in the proper court under the provisions of order number 7, rule number 10. But it is very important to note here that court has no power to dismiss the suit on this ground that the valuation which is made by the plaintiff was overvalued or undervaluation. If there is any objection regarding the pecuniary jurisdiction to entertain and try a particular suit, that must be taken in the court in which the suit is instituted at the earliest possible opportunity. If such an objection is not raised before the trial court and the matter goes in appeal or goes in revision, then the appellate or revisional court may not allow the objector to raise the plea of without jurisdiction in support of his case. That means to say, if any person has any objection in respect of the jurisdiction of the court, that objection must be taken at the earliest possible opportunity. If that objection is not raised before the trial court, then that objection may be ignored by the appellate or revisional court. So this is something about section number 15 of the code. So friends, if you like my lectures and want to watch more law lectures on my channel, then please subscribe my channel and do not forget to click on the bell icon to get notifications of my next videos. If you like my videos, then please like my videos, share my videos, and if any one of you want to take notes of my law lectures, then you can visit my blogs at lawarticles2020.blogspot.com to get notes of my law lectures. Thank you very much.